This is a presentation of basic rights in special education. This presentation is an overview of the basic rights and responsibilities of parents who have children receiving special education services, and it is designed to give you a basic understanding of the process and parental rights. SPAN offers in-depth workshops on many of the topics that will be touched on today. Parents who have a better understanding of the process are better prepared to take an active role in the planning of their child's educational program. Today, participants will learn the details of the special education process and parental rights and responsibilities. They will learn to identify dreams and goals for their student, and they will learn advocacy strategies to help them reach those goals. SPAN is a statewide organization that is federally funded by the U.S. Department of Education Office of Special Education Programs. We are an umbrella organization that focuses on education, health, parent leadership, and human services. We offer training, technical assistance, information, and support to families and parents of children with disabilities and special health needs, or those who are at risk of inappropriate classification. The information we will be covering in this presentation are part of a federal law known as IDEA, Individuals with Disabilities Education Act. This law ensures that children with disabilities receive a free, appropriate public education, FAPE, in the least restrictive environment, LRE. It also provides parents with the right to participate in their children's education. Parents and representatives of the school district are team members who are responsible for developing an appropriate educational program for their child. That program is called the IEP, Individualized Education Program. This law was enacted to ensure that children with disabilities receive educational benefits that allow them to progress from grade to grade while learning the same knowledge and skills as their non-disabled peers. The law is there to provide the services and supports needed for a child with disabilities to become a productive adult, contributing to their community. This should be our focus throughout the entire process. It's when we lose our focus on the student that difficulties arise or the process breaks down. Parents are an equal partner in the special education process with the right to give or withhold consent for each evaluation and for initial services. Parents need to be at every decision-making meeting, whether that's in person, on Zoom, on the phone. Schools and parents should be able to work something out to be available for all meetings. And parents can share their concerns so that school personnel understand what their concerns are for their child. This presentation will focus on providing a better understanding of the special education delivery cycle. This slide shows an overview of that cycle. We will go through each step in this cycle throughout this presentation. Step 1 is identification. It's also referred to as referral. Referral happens when a child is suspected of having a disability and might need special education services. The referral must be in writing. Parents can refer their own child. Once it receives the written referral, the district must hold a meeting within 20 calendar days to decide if an evaluation will be conducted. Parents must provide written consent for that initial valuation and for all future evaluations. If an evaluation will be conducted, another decision is made about the nature and scope of the evaluations. This is called a planning meeting. Once you give the written consent, the district can begin to evaluate your student. It's a good idea to get a copy of the consent before you leave the meeting. The consent contains all the information of what evaluations will be done. In addition, you can ask to be notified at least 24 hours in advance of the scheduled evaluation so that you may adequately prepare your child. Moving on to step 2, evaluation. When you, the members of the child study team, and your child's teacher meet and decide that your child may have a disability and evaluations are needed, the evaluations must cover at least 2 areas of concern. They must be conducted in your child's primary language and in all areas of suspected disability. And if the child has challenging behaviors, a functional behavior assessment should be done. Many students are referred to special education because of behavior. If that is the case, a functional behavior assessment should be conducted. You have the right to request an independent evaluation at the district's expense if you disagree with the evaluation. If you believe that the evaluations done by the school district do not accurately reflect your child's strengths and needs, you may request an independent evaluation. That request must be done in writing. An independent evaluation is done by a qualified person outside of your school district. They are not employed by your school district. The independent evaluation is done at public expense if it is agreed to. You can request multiple assessments under your one independent evaluation request. So it's important to know that when you make your independent evaluation request, you should request all needed assessments at that time. The independent evaluation must be at no cost to you, and it must meet the same standards as the district's evaluations. If the district disagrees that an independent evaluation is needed, the district must file for a due process hearing within 20 days of your written request. Step 3, eligibility. Upon completion of the evaluations, parents are notified of an eligibility conference. Evaluation reports should be sent to parents at least 10 days before the eligibility conference so that parents have ample time to review those reports. If you do not receive the written reports when you receive the letter of invitation to the eligibility meeting, make sure that you contact the case manager and advise them that you will need to reschedule the meeting if they are unable to provide the written reports in a timely manner. Based on the results of the evaluations, a determination of eligibility for special education services will be made. To be eligible for special education and related services, a student must have a disability according to one of the eligibility categories. The disability must adversely affect the student's educational performance, and the student must be in need of special education and related services. These are the eligibility categories for special education services that are recognized under the law. The other health impaired category that's in the middle of the page, that usually includes ADHD. Preschool disabled, which has a star next to it, is a category for children between the ages of 3 to 5 years old who are experiencing developmental delay in one or more areas and require special education and related services. Developmental delay means either a 33% delay in one developmental area or a 25% delay in 2 or more areas. The category eligible for speech language services refers to a student who has a speech disorder in articulation, phonology, fluency, voice, or any combination of those that is unrelated to cultural differences or influence of a foreign language. This category is not an option for students ages 3 to 5. Once a student has been determined eligible for special education services, the team begins to develop the IEP. Although these are two separate meetings, they are usually held back to back, the eligibility meeting and then the development of the IEP meeting. The IEP team. Parents are equal members of the IEP team. Listed here are the roles that must be present on the IEP team. It doesn't need to be 6 individuals that are present, as one person could take on multiple roles. If at any time any of these roles will not be present at the meeting, the parent must give written consent for that team member not to be there. With parental written consent, a member of the team may be excused from the meeting if they provide written information to the team in advance of the meeting. A request for excusal must be in writing and should be sent with the notice of the meeting. Also, it's important for students to be at the IEP meeting for as long as they are able to be. They can learn the process and learn how to advocate for themselves by participating in their IEP team meetings. At the meeting to develop the IEP, we will go through the different sections of the IEP document. The IEP is a written plan that describes the child's special education program in detail. The PLAF is the present levels of academic achievement and functional performance. It's often referred to as the PLAF. This is the narrative section that describes a student's learning and educational needs. Summaries from the most recent evaluations should be included in this section. The PLAF must address both academic and functional performance, and it should include both strengths and needs. Measurable annual goals should be current, objective, and tied to the general curriculum. They should address every area of need. Special education services includes specially designed instruction or supplementary aids and services. Related services must be defined with the beginning and ending dates of service and the location, duration, and frequency of the service. Related services can include occupational therapy, speech therapy, physical therapy. It can also include busing, transportation, and extended school year. Placement decisions should be based on educating the student in the least restrictive environment appropriate. The placement decision should happen at the end of the meeting, once the needs and the goals of the student have been agreed upon. Parental concerns section of the IEP includes your concerns related to the IEP or your child's experience at school. The transition plan, we start discussing this at age 14 in New Jersey. This focuses on the child's goals for the future beyond high school and how to address how those goals will be achieved. So that will include what educational or other steps must be taken to help the student reach their goals for after high school. Participation in assessment is included in the IEP as well. This is a discussion of statewide testing and what that will look like for this student. Some students with IEPs will take the statewide test that all general education students will take. Some will do that with accommodations. Some will take alternative proficiency assessments, like the DLM. Student needs are also addressed in the IEP. A behavior intervention plan should be included in the IEP if one is being used, as well as how behavior is observed and monitored. Language and communication must be addressed as well. Does the student speak another language primarily, or do they use an assistive communication device? Assistive technology should be addressed in the IEP as well, and parents can request that an assistive technology assessment be done to determine what is needed. Assistive technology can range from low-tech to high-tech accommodations, including a pencil grip or a Chromebook, and anything in between. Extended school year, often referred to as ESY, should be addressed in the IEP as well. Any student who is at risk of regressing during the school year in their skills and knowledge should be included in extended school year programs. Participation in non-academic activities, extracurricular activities, can be addressed in the IEP as well, and the needs of students who have visual or hearing impairments must be addressed as well. Your child has the right to be educated in the least restrictive environment, LRE, where their IEP can be implemented and they can make progress towards their annual goals. This means that all students, regardless of their disability, are to be educated in age-appropriate general education classes in their neighborhood school. All necessary supports are to be provided to students and educators to ensure meaningful participation in the total school community. So the placement discussion during the IEP meeting should start with questions like, how can we implement this IEP in the general education classroom with supports and services? Or, is there any reason why this IEP cannot be implemented in the general education classroom with supports and services? Any decision to remove a child from the general education classroom must be justified in writing in the IEP. This is a continuum of placement. There are other options beyond this list. These are just examples of placement options. It's meant to give you an idea of the various placement options that are often used. The starting point for discussion at each IEP meeting, no matter where your child is currently receiving services, is the general education classroom with needed supports, services, modifications, and accommodations. A child should not be removed from their general education classroom due to administrative convenience, cost, objection of general education parents or educators, or because they can't keep up in the regular class. Even if your child is in a self-contained or out-of-district placement, the IEP must provide opportunities for your child to interact with non-disabled peers. Each year, the IEP team must discuss strategies to lead to your child being in a less restrictive environment. The parent must consent to the initial IEP before it can be implemented. If you do not consent to the IEP, the district is no longer obligated to provide FAPE. Once your child is receiving special education services, your consent is not required for the district to change the IEP so long as they provide you with adequate notice and the opportunity to participate in decision-making. If you disagree with the proposed change, you must request mediation or due process to stop the proposed change from taking place. Parents are allowed to withdraw consent for services. The school district still has an obligation to educate the child in general education. and the district may still be required to provide services under Section 504 of the Rehabilitation Act if the child has a disability. The decision to withdraw consent for special education services should not be made lightly, and it can mean the loss of disciplinary protections for the student. However, it may be an appropriate action for students who are not able to access the general education curriculum because of placement in a segregated setting. The IEP requires a statement of what methods will be used to inform parents of student progress. That is, report cards, progress reports, conferences, phone calls, emails, a daily checklist, a communication notebook. A statement or schedule of the frequency of each method used is also required to be in the IEP. Parents must be regularly informed of their child's progress towards mastering the goals in the IEP. Progress reports need to be received regularly, which means they need to be received just as often as students without IEPs get progress reports. Step 7, the annual review and reevaluation. Every year, the IEP team meets to review the past year and to develop an IEP for the next school year. Remember, you can call for an IEP meeting at any time, but at a minimum, you must have an IEP meeting at least once a year. Every 3 years, the IEP team will meet to determine if the child is still eligible for special education services. This will include a discussion about evaluations that may need to be done to determine continuing eligibility. And remember, the student is part of the IEP team. So that was the last step of the special education delivery cycle. It is a continuous cycle. Remember, every 3 years, the district will contact you to discuss a reevaluation plan. In most cases, you will want to have your child reevaluated to ensure that you have up-to-date information for educational planning and programming. Now we can discuss additional rights that parents have. These are ways to assist parents in being effective members of the team and having full participation in the educational decision making for their children. So families have the right to an IEP meeting upon request. They have the right to receive advanced written notice of any proposed meeting. They have the right to have meetings conducted in your primary language. You have the right to access information that you need to participate in decision making. So, for example, if a new reading program is being proposed, you have the right to have information about that program so that you can participate meaningfully in deciding whether it is appropriate for your child. Parents also have the right to bring someone with them to the IEP meeting. And that's a good habit to get into, to have someone there for support, to have an additional set of eyes and ears, maybe someone to take notes. You can also record the meeting, but you have to let the school district know that you plan to record it ahead of time. Students have the right to program access. This means that they have the right to access the same variety of education and support services as non-disabled peers. It's important to know what options are available to students in the school district. Students who are classified should have access to the same options as non-disabled peers. And the IEP team should discuss those options and what supports or services are needed for the student to have access. Students have the right to access extracurricular activities. They have an equal opportunity to participate in non-academic and extracurriculars. These can include counseling, athletics or recreation activities, transportation, health services, special interest clubs, referrals to employment. Basically, any activities that non-disabled peers have access to, students with IEPs should have access to as well. You have the right to access your students' records. You have the right to review and get copies of your child's records before any meetings. You also have the right to keep your child's records confidential. You can request removal of inaccurate or inappropriate information that is in your child's records, and you have the right to attach your own explanatory or disagreeing statement to your child's records. You have the right to notice and response. Districts have to ensure that notices are sent in the parent's native language. The district has 20 days to respond to you, and you have 15 days to respond to the district. Parents have a right to a detailed written explanation of why your district or school is planning on taking an action or refusing your request in your language. Sometimes disagreements reach the point where we feel we need to move to the next level and have a mediator or a judge help resolve the situation. In mediation, a representative from the state will come in and mediate the IEP meeting. Due process or impartial hearing is a legal proceeding where an administrative law judge presides and listens to the testimony from witnesses regarding the dispute. This process can be costly financially as well as to your relationships with the school personnel. So it is something to not jump into lightly, but it is your right to do so if you feel that it is necessary, and sometimes it is. A complaint investigation is a complaint that is filed with the state regarding systemic issues at the school. Excuse me. These are issues affecting a large number of students, not just your student. So for an example, maybe speech therapy is not being provided to any student at the school. That would be a time when a complaint could be filed with the state. If you request an impartial hearing, you must first give the district the chance to resolve your disagreement by participating in what's called a resolution session, which is held by the district. This is a last resort to resolve the dispute. Resolution sessions must be scheduled within 15 days and completed within 30 days. Unless the parent brings an attorney, the school attorney is not permitted to attend the resolution session. If a resolution is reached, a legally binding written agreement will be executed. Disagreements are most successfully resolved at the local level. Listening is the most cost-effective skill you could use to avoid a disagreement or in preventing one from escalating. The savings from active and reflective listening come from decrease in disagreements, promoting teamwork and saving time. So if listening is cost-effective, not listening can be costly. It can lead to mistakes, poor teamwork, and wasted time. Listening leads to problem solving. Sometimes speakers just need to be heard. Sometimes listening can clear up confusion, and listening identifies a need for problem solving. One of the most common reasons parents tell us that they are filing for due process is because the school or district just won't listen to me, or it's useless to keep talking because they don't hear a word I'm saying. So active listening on both sides is really important to de-escalating or avoiding disagreement. Parents have the right to procedural safeguards. Procedural safeguards ensure that the rights of children with disabilities and their parents are protected. They ensure that students with disabilities and their parents are provided with information that they need to make decisions about the provision of FAPE. The procedures and mechanisms are in place to resolve disagreements between parties. These are some helpful hints as you navigate the system. Teach your child self-advocacy from the beginning. Explain each step of the process to your child and help them understand their strengths and needs. Bring them to the IEP meetings and encourage them to express their hopes and dreams and visions and goals, and have high but realistic expectations for your child. All of this will help them to develop their own self-advocacy skills as they grow up. More helpful hints, get it in writing. It's important to get everything in writing. All communication should be done in writing. Ask for what you want in writing, keep logs and copies of everything, and bring someone with you to the meeting. That can be invaluable to have the support and to have someone else listening or taking notes. Don't be afraid to ask or speak up and stay on top of your child's progress. You don't want to get to the end of an IEP year and realize that your child hasn't been making progress all year towards their goals. So try and stay on top of your child's progress monthly or quarterly as you get reports. Reach out to teachers to see how it's going so that you can be on top of it throughout the year. And if any problems arise, you can address them in the moment. Parental input, monitoring, and ongoing involvement leads to student success. Educational outcomes are improved when families, schools, and service providers are working together effectively. These are some resources that can be helpful in understanding your rights. Our website has a lot of resources, as well as the Center for Parent Information and Resources website, which is our website is www.spanadvocacy.org, and the Center for Parent Information and Resources is www.parentcenterhub.org. The Parental Rights in Special Education book is something that should be provided to you by the school district when you are invited to a meeting. You can also access it online at that link. Thank you for attending this presentation. Our contact information is here on this slide. Our toll-free number and our phone number are ways that you can contact us for technical assistance. With any questions that you may have, please reach out.